Hello and welcome to TaxPundit. The case under discussion is Pricewaterhouse Coopers Private Limited versus Assistant Commissioner of Income Tax, Calcutta High Court, pronounced on 25 June 2026. This case involves Pricewaterhouse Coopers Private Limited, a consultancy firm, which filed its income tax return for assessment year 2024-25 in November 2024, declaring a loss of over 52 crore rupees. They later revised that to a loss of about 42.5 crore rupees in June 2025. The tax department selected their case for scrutiny assessment through the National Faceless Assessment Center. On 22 December 2025, the case was transferred from the Faceless Center to the Jurisdictional Assessing Officer. The JAO then issued several notices under Section 142(1), calling for information, and the petitioner complied each time. However, the critical moment came on 28 March 2026, when a show cause notice was issued alleging the petitioner's role in a specific corporate acquisition. The show cause notice gave only 2 days to respond. The petitioner submitted their reply on March 30th, but on that very same day, the assessing officer passed the final assessment order, raising a massive demand of over 87 crore rupees. No personal hearing was provided, and it appears the reply was not considered at all. This has formed the basis of the legal challenge. The High Court, presided over by Justice Smita Das De, found a clear violation of the principles of natural justice. The cornerstone of fair procedure is the rule that no one should be condemned without a hearing. Here, the petitioner was given just 2 days, and the order was passed immediately after receipt of the reply. The court noted that CBDT instructions mandate a proper show cause notice and consideration of the response, and cited precedents like Inox Wind Energy and Sahara India to reinforce that natural justice must be read into tax provisions. The tax department argued that the petitioner should have filed a statutory appeal instead of a writ petition. However, the court clarified that the existence of an alternative remedy does not bar the High Court's writ jurisdiction under Article 226. It is a rule of discretion, not a legal bar. And where there is a gross violation of natural justice, as here, the court can and should intervene. The court relied on Supreme Court judgments like Godrej Sara Lee, Whirlpool Corporation, and others. The court quashed the assessment order and all related demand and penalty proceedings. However, it did not end the matter entirely. The case was remanded back to the assessing officer for a fresh assessment, with strict directions to provide a meaningful opportunity of hearing, including considering all previous replies. The fresh assessment must be completed within 8 weeks. This balances the taxpayer's right to fairness with the revenue's interest. Frequently asked question: what was the main reason for quashing the assessment order? The court found a clear violation of natural justice because the show cause notice gave only 2 days, and the order was passed immediately after the reply without any hearing or consideration. Another common question: why didn't the court ask the petitioner to appeal? The court explained that the alternative remedy rule is discretionary and not absolute. When fundamental fairness is denied, the High Court can directly entertain a writ petition, as supported by multiple Supreme Court decisions. What's the significance of the transfer from faceless assessment to the jurisdictional officer? The court made clear that even after transfer, the JAO must follow due process, including issuing a proper show cause notice with proposed disallowances. The Inox Wind Energy case was cited to support this. Question about the demand amount: the quashed assessment order raised a demand of over 87 crore, 20,87,760 rupees. A very significant sum. What happens next? The case goes back to the assessing officer for a fresh assessment, which must be completed within 8 weeks. The officer must give the petitioner a proper hearing and consider all previously filed replies. Finally, can the tax department appeal this judgment? The source doesn't say, but generally the revenue can appeal to the Supreme Court on a question of law. For now, the High Court's decision stands. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at 932-630-6668 for any assistance. Don't forget to subscribe for more landmark updates.